Hello, and welcome to today's presentation on the new HIPAA rule and its impact on health plan sponsors. The Department of Health and Human Services, or HHS, issued a final rule under HIPAA's Administrative Simplification provisions on January 25, 2013. The rule updates HIPAA's privacy, security, and breach notification rules. It also includes changes required by other pieces of legislation, namely the HITECH Act and the Genetic Information Non-Discrimination Act, or GINA. The final HIPAA rule creates new requirements for health plans and their business associates. To highlight key provisions, the final rule makes significant changes for business associates, including expanding the definition of business associate to include subcontractors, revises the HITECH Act's breach notification standard for unsecured protected health information, or PHI, and expands individuals' rights under the HIPAA privacy rule. The deadline for complying with changes made by the final HIPAA rule is September 23, 2013. However, the compliance deadline for updating existing business associate agreements is extended for up to 1 year until September 23, 2014. The extent of a plan sponsor's obligations under the HIPAA rules largely depends on how its health plan is funded, that is, if it is self-insured or fully insured, and also on whether the employer has access to PHI to administer the plan. Sponsors of self-insured plans must generally comply with the entire scope of the HIPAA privacy and security rules. Sponsors of insured plans that do not have access to PHI, except for summary health information and enrollment and disenrollment information, have minimal obligations under the HIPAA rules. The health insurance issuer is primarily responsible for complying with the HIPAA rules in this situation. The final rule implements the HITECH Act by making business associates directly liable for complying with the HIPAA rules. Prior to the HITECH Act, business associates were liable for compliance only through their business associate agreements. Also, the final rule expands the definition of business associate to include all entities that create, receive, maintain, or transmit PHI on behalf of a covered entity, including subcontractors. Under the final rule, entities that store PHI in hard copy or electronic format are business associates even if they do not access, use, or disclose that information. The HITECH Act requires covered entities to notify affected individuals following the discovery of a breach of unsecured PHI. Covered entities must also notify HHS and, in some case, the media when there is a breach. The final rule creates a new, more objective standard for covered entities to use to determine if a breach has occurred. Under the new standard, an impermissible use or disclosure of PHI is presumed to be a breach. However, notice is not required if the covered entity performs a risk assessment and can show that there is a low probability that the PHI has been compromised. The final rule expands individual rights. For example, upon request, covered entities will have to provide individuals with access to the electronic PHI contained in their designated record sets in the electronic form and format requested by the individual. Also, if an individual pays in full and out of pocket for a service or item, the individual may request that the healthcare provider not share the PHI related to that service or item with the group health plan. In addition, to comply with GINA, group health plans cannot use or disclose PHI that is genetic information for underwriting purposes. Group health plans will need to review their business associate agreements to determine if they need to be updated for the new HIPAA rule. Also, because the definition of business associate has been expanded, new agreements with service providers may be necessary. Business associates that use subcontractors are responsible for entering into business associate agreements with their subcontractors. Also, the deadline for revising existing business associate agreements has been extended for up to 1 year until September 23, 2014. This extension only applies to updating the paperwork with business associates. It does not extend the time allowed for the health plan and business associate to comply with changes made by the final rule. Limitations apply related to renewals and changes before the extended deadline. To comply with the final rule, health plans should update their HIPAA policies and procedures for the rule's changes. For example, revisions should be made for the new breach notification standards, expanded individual rights, and the prohibition on using genetic information for underwriting purposes. Also, health plans must update their privacy notices for the final rule. A health plan that posts its privacy notice on its website must post the revised notice by September 23, 2013, and provide the updated notice with its next annual mailing to participants. If a health plan does not maintain a website, it must provide the revised notice within 60 days of updating the notice. Thank you for viewing today's presentation on the new HIPAA rule and its impact on health plan sponsors.